So in this part of our two-part video, we're going to continue the anatomy of an employment tribunal claim being brought by an employee. And we've covered in the first part time limits, what a claim looks like, how to bring it, and what are the steps associated with a preliminary hearing. And just as a reminder, I'm joined by my friend and colleague Jessica Wells to cover this part of the video. Now, Jessica, I want to ask you about the final hearing. What's involved in that?
So the final hearing is the last stage of bringing a claim. So the final hearing is where the parties attend a hearing, and that can be either in person or it can be online, something called the cloud video online way of attending tribunal claims. And that's very similar to a Microsoft Teams meeting, and we're seeing more and more frequently now, especially after COVID, that they're online. So the final hearing is when a tribunal or an employment judge sits down, listens to the evidence and makes a decision on the outcome of that claim. Now, claimants and respondents, they can represent themselves at the final hearing if they want to. There is nothing stopping them from doing that, and they don't have to engage in any kind of legal advice throughout. It's always recommended, but they don't have to. But at the final hearing, typically you would see both parties represented by a barrister. So that's really what the final hearing is. Now, the process of the final hearing is that the tribunal judge will potentially take some time at the beginning to read through the crucial documents, read through and remind themselves of the list of issues at the beginning, what they need to look into, what they need to find answers to. And then secondly to that, the representatives, so potentially the barristers, they make opening submissions. Now, the opening submissions are the key arguments, the key points that need to be raised within that hearing, so it really focuses the parties' minds. And then after that, it's a case of the evidence being raised, being discussed. So it will be both parties raising their evidence, and if witnesses are being brought along to the hearing, then they will give their evidence as well. And as part of that, there will be a cross-examination, so from one side's barrister to the other side's witnesses, and vice versa. So that's really getting the information out of the witnesses. Now, witnesses beforehand will have produced witness statements, as we discussed in the first part, but typically witness statements are considered as read, so they won't have to read their witness statements again. But it's important beforehand for all parties to remind themselves of what's in the bundle, so they know really what's going on. Once the evidence part of the final hearing has been done, again, like the opening submissions, there'll be closing submissions. So again, it will be focusing the parties' minds as to what the tribunal really need to make a decision on, and the final points that need to be considered. And after that, it will be the decision part of the final hearing. Now, it doesn't mean that a decision will be made there and then. Sometimes the tribunal judge will need to adjourn the hearing and will need to go off and consider the points, come back and make their decision. Or it can be something called a reserved judgment, where actually the hearing is paused, it's stopped, and then later on the judge will produce a written form of his decision that would come out to the party. So it really depends on the complexity, how the time is being handled throughout the final hearing. So parties shouldn't expect to receive that judgment there and then, because that may not be the case. Now, in terms of the timings of a final hearing, they can be from a couple of days, and they can go up to a few weeks. It depends on the complexity, it depends on the number of witnesses being brought along to the hearing, so it really depends. But at some point before the final hearing, potentially at the preliminary hearing, or even possibly before, the tribunal will make the parties aware of where it will be, how long it will be, so everyone will know in good time. And at the preliminary hearing, if there is one, and if the dates of the final hearing are raised, then parties should make themselves available to meet those dates, and it's only in exceptional circumstances that they can be changed. So again, something to consider. And it is, even if the parties have representatives going along, so the barrister going along to represent them, it's always beneficial, both in the preliminary hearing and final hearing, for the parties to go themselves. So really that's the overview of the final hearing.
Yes, and a quick postscript on that. It's worth mentioning that if the employee is saying that their dismissal was unfair, and the dismissal was actually dealt with by the employer, so the employer dismissed the employee, then the employer goes first in giving their evidence, because the burden is upon them to prove that the dismissal was fair.
Absolutely.
Statutorily and also procedurally fair as well. If, on the other hand, the employee is bringing a discrimination claim, where they're trying to argue that they've been discriminated against on grounds of, let's say, age or disability or sex or race or sexual orientation, for example, then the burden is upon them to prove their case, and it is their evidence that goes first. That's right, isn't it?
Absolutely. Whoever's got the burden of proof, they go first to present their evidence.
So, Jessica, we've learned about the anatomy of an employment tribunal claim, what happens when one is brought, how to bring one. But can I ask you, is it for everyone? Is this a suitable route for most employees, all employees for that matter? What's your response?
So, provided that the employee meets the time limits or the qualifying service criteria, absolutely. A claim is, and it's available for every employee to go down if they want to. So it's a process that is it's completely open for individuals to go down. It's a process that's directed to allow claimants, employees to seek redress where they have issues at work or with ex-employers. So it's very open, and it's there to use for employees. So it's suitable and employees can use it, but some employees may choose not to use it for some of the reasons we've discussed. But kind of summarising those, there are benefits to bringing claims. So it provides redress in a formal setting, which some employees, they wanted on a piece of paper that they have been treated badly, and that can be a really important part. If successful at a tribunal, potentially compensation can be higher in a tribunal setting if awarded than it would be potentially if there is a settlement involved, because that involves some kind of negotiation. But the drawbacks are that it can be incredibly time consuming. It can take up to a couple of years. It can be incredibly emotionally taxing. It's really difficult, especially if concerns and issues are being brought back to the surface for employees that they've forgotten about or didn't want to think about. So it can be really difficult, and it's certainly something to consider. And like we've discussed, it can be incredibly costly as well, especially if legal advice is brought in. Although we recommend that legal advice is brought in to provide correct advice regarding the claims and time limits and things, but it can be costly, which is why potentially the home contents insurance can be quite an important consideration for employees. And I'll go back to the settlement point in that there are other alternatives to not bringing a claim. So settlement can be raised. It's a good way of hopefully providing an amicable solution to an issue. And we have previously filmed a video on settlement agreements. So if there are any people watching who have questions or queries about how do settlement agreements work and what that process looks like, then I'd encourage them to go and watch that. But it can be a really good thing to involve themselves in, and typically respondents and claimants can see the benefit of settling a dispute before it reaches the tribunal. So it can be accessed by most people provided they're able to bring the claim, but some individuals may choose not to for the reasons as previously outlined.
Okay, thank you very much. And finally, what is it that we can do to help employees in those circumstances where they're contemplating bringing a claim against their employer?
Yeah, so there are some difficult stages throughout. Bringing a claim is a tricky one. It's not an easy process to go down, and there is a lot of legal consideration that needs to be made. So that's why we're here. So actually bringing the claim, the conciliation process, that's something that we can assist with. We can assist with drafting the claim documentation and talking an employee through what that means. And even at the beginning, employees may be thinking, well, I know something's gone wrong, but I'm not quite sure how to convert that into the tribunal. Now that's for us to have a look at, and we can have a look at the details, have a look at the correspondence that they may have, and actually convert their grievance into a potential claim. And we're there to provide them support in how they do that, what that means. And going through the actual hearing process itself, we can assist with that, or we have really good relationships with barristers who do this regularly. They're people that we work very closely with, and that's something that we can provide support with as well. And we're not just there to assist with the legal aspect of it. We know what it's like to go through this. We see it often, and we're there to talk to individuals, to provide support, because it's not an easy process. So we can definitely try and alleviate some of the anxieties that form around bringing a claim.
And I think it's also important for employees to know if they're going to win. Now, we can't give a guarantee that they're going to win their case, but we can usually, having looked at the documentation, the correspondence between themselves and their employer, the manner of dismissal, the reason for dismissal, what was said, what was done, who said what to who, we can usually give a fairly strong indication in percentage terms of whether they are likely to succeed or not. And that may be only 51%. That is, in real terms, still reasonable prospects of success. It's more than 50-50, but it may not be as high as 100%, because we can't simply give that sort of guarantee that they will win hands down at the tribunal, because a lot depends on how the evidence goes on the day and who is presenting themselves as a more credible witness. And often documentary records are crucial to a case, and they often will help determine how a case is won or lost. So that's pretty important for all employees looking to bring a claim. So I hope that's been helpful for any employees out there who are looking to make claims against their former or their current employer, whether for unfair dismissal or discrimination or any other kind of relief that they may want to obtain through the employment tribunal system. So we're here to help guide you and advise you on the process. So I hope that's been useful.